Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People ex rel. Danielle Welch Villanelle Maginley-Liddie, decided on June 17, 2025. Garcia, J. CPL 510.10, 4, provides a judge with discretion to set bail on certain otherwise non-qualifying offenses committed after a defendant has been released under conditions on a prior charge. The issue raised on this appeal is whether a defendant who is arrested on new charges after having been released on bail on the prior, underlying charge is released under conditions within the meaning of that provision. We hold that the statute applies in such circumstances, and because affirmative habeas relief is no longer available, we reverse the appellate division order to convert the proceeding to a declaratory judgment action and grant judgment in accordance with this opinion. The 2019 bail reform legislation eliminated cash bail for most crimes, except for certain specified qualifying offenses listed in CPL 510.10, 4, see People ex rel. Rankin v. Bran. In 2020, the legislature amended subdivision 4 by expanding the categories of offenses that qualified for bail. The changes included the addition of CPL 510.10, 4, a harm-on-harm provision, by which an otherwise non-qualifying offense may be converted into a qualifying offense. People v. Lee, CPL 510.10, 4, see report on the 2020-21 adopted budget, at 8. Part 2 of the adopted budget creates a mechanism for repeat offenders to be assigned bail. Under that provision, certain ineligible crimes may otherwise qualify for bail if those crimes arose from conduct occurring while the defendant was released on his or her own recognizance, released under conditions, or had yet to be arraigned after the issuance of a desk appearance ticket for a separate felony or Class A misdemeanor involving harm to an identifiable person or property. CPL 510.10, 4, For purposes of Section 4, the underlying crime need not be a qualifying offense. In 2022, defendant was arrested and charged with several felony offenses, including attempted murder, a qualifying offense. See Penal Law Section 125.25, 1, CPL 510.10, 4, a. The court set bail, which defendant posted, and he was released. The following year, while out on bail, defendant was arrested on charges of theft, larceny, and criminal possession of stolen property. See Penal Law Sections 155.25, 165.45, 2, 165.40, 190.79, 1. The new charges standing alone were not qualifying offenses, but at defendant's arraignment the people asked the court to set bail under CPL 510.10, 4, noting that he allegedly committed the instant theft offenses while released on an underlying attempted murder charge. Defense counsel asked the court to impose supervised release given defendant's ties to the community and his appearance record in the underlying case. Instead, the court set bail, explaining that defendant was before the court on an otherwise non-bail qualifying offense, which is alleged to have been committed while at liberty on bail for a prior violent felony, and concluding that bail was appropriate under the circumstances to ensure defendant's future appearances at court. Defense counsel made bail applications at several subsequent hearings, contending that the original securing order made pursuant to CPL 510.10, 4, was improper and asked the court to release defendant to supervised release. Counsel argued that CPL 510.10, 4, only applies to those defendants who are released on recognizance or released under non-monetary conditions, and is not implicated where a defendant is released on the separate condition of bail. Because defendant was not at liberty based on the court releasing him under conditions, counsel asserted that the statute did not apply. Each of these applications was denied, with the courts rejecting defendant's interpretation of the harm-on-harm provision. Defendant's counsel then commenced this habeas proceeding before the appellate division seeking defendant's release on the ground that CPL 510.10, 4, did not apply and that as a result, his later theft charges could not be considered qualifying offenses. The court rejected defendant's reading of the statutory language released under conditions as excluding bail, explaining that such an interpretation would require writing the phrase non-monetary into the statute. Instead, The court held that the use of the term conditions without the non-monetary modifier evidenced the intent of the legislature to apply that statute to all conditions of release rather than only non-monetary conditions and dismiss the writ. Defendant was subsequently released upon posting bail. Defendant first argues that bail is not a condition of release at all and therefore the language released under conditions as used in CPL 510.10, t, does not encompass a defendant who is released on bail on an underlying offense. If bail is posted on behalf of the principal and approved, the court will permit the principal to be at liberty during the pendency of the criminal action or proceeding involved, CPL 500.10, That is, the principal is released on the condition that they have paid the amount set by the court. Accordingly, bail is a condition of release and a defendant who posts bail has been released under conditions. Defendant also asserts that, even if bail is a condition, we should interpret the phrase released under conditions as applying only to defendants released solely on non-monetary conditions on the underlying crime. According to defendant, Section 4(t) was meant to apply to the narrow group of defendants who had been released without bail and gotten rearrested on additional bail-ineligible offenses, and claims that in passing Section 4(t), the legislature closed a gap in the bail statute, returning discretion to judges to set cash bail on those individuals with multiple open non-qualifying cases. Defendant maintains that this new section was not necessary for individuals who had posted bail, as they necessarily had an open qualifying offense that was subject to modification under a different statute. As an initial matter, the legislature uses no such limiting language in this portion of the statute. Whereas elsewhere in 4(t), the statute refers to defendants released, under appropriate non-monetary conditions, here only the more general language released under conditions is used, see CPL 510.10, Moreover, the plain terms of CPL 510.10, disprove this argument, making clear that the less restrictive meaning of conditions was indeed intended. The provision states that the underlying crimes need not be a qualifying offense as defined in the subdivision, meaning, of course, that the underlying crime may be a qualifying offense and that bail, as a condition of release, may be set for such offense. There is no dispute that Section 4(t) would apply had the trial court exercised its discretion and released defendant on non-monetary conditions rather than setting bail on the underlying qualifying offense, see CPL 510.10. Upon a subsequent arrest, defendant, in that situation out on non-monetary conditions, would be bail eligible on the new charges even though defendant's status in the original case could instead be modified and bail set on the underlying charge. Yet this is the same result faced by a defendant who initially had bail set on that underlying offense, see CPL 530.60, and therefore defendant's argument that those already subject to modification for a bail-eligible offense do not fall within Section 4(t's purview fails. Nothing in the statutory language limits its application only to those defendants with open non-qualifying cases who have been released on non-monetary conditions. Rather, CPL 510.10, applies to a defendant who is released under any condition, including bail, consistent with the statute's goal to create a mechanism for repeat offenders to be assigned bail for non-qualifying offenses allegedly committed while released on another charge. Report on the 2020-21 adopted budget, at 8. See People v. Brown. In such circumstances, those non-qualifying offenses are classified as qualifying offenses, and judges are authorized to impose bail. Brown. Whether a judge in any such case chooses to do so is, of course, within their discretion. Accordingly, the judgment of the appellate division should be reversed, without costs, the habeas corpus proceeding converted into a declaratory judgment action, and judgment granted, declaring that a defendant who is arrested on new charges after having been released on bail on a prior charge is released under conditions within the meaning of CPL 510.10, I join in affirming the appellate division, but without adopting the majority's extraneous and flawed proclamation that, other than for purposes of CPL 510.10, a statutory reference to conditions necessarily includes bail. When the legislature intends that result, it uses clarifying language, as it did in Section 4(t). Enough said. Judgment reversed, without costs, habeas corpus proceeding converted to a declaratory judgment action and judgment granted declaring that a defendant who is arrested on new charges after having been released on bail on a prior charge is released under conditions within the meaning of CPL 510.10, Opinion by Judge Garcia. Judges Singas, Canataro, Troutman and Halligan concur. Judge Rivera concurs in result in an opinion, in which Chief Judge Wilson concurs. Decided June 17, 2025.
Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law